The one asset that has traditionally caused the most angst during divorce negotiations is, oddly enough, the retirement account. The 401k, the deferred compensation, IRAs, and pension plans. Spouses traditionally become very territorial when it comes to these assets, perhaps because it represents their life savings or what they envisioned they were going to do with the future, maybe more so now because of the uncertainty of the pandemic. But for whatever reason, they are very contentious when it comes to dividing up the asset. And we as attorneys will often hear the question, why do I have to divide my retirement account with my spouse? It was my income that led to the increase in this asset. Well, we go back to that same premise that all income earned during the marriage is marital. And it was that income, in theory, that funded some of these accounts. So what happens with them? What happens with these accounts during the divorce? In New York, these pension accounts, whatever accumulated in those accounts during the marriage is marital, and therefore subject to division and distribution. So, if the parties can't settle this issue and it remains out there for the court, what the court will do was they will award a portion of that account to the non-title spouse. What portion? Clients will often hear, oh, it's pursuant to the Majauskas formula. Majauskas is the name of a landmark New York State case which set the standard. And that is basically the non-title spouse will receive 50% of what accumulated during the marriage. And what are the key dates? The date of marriage and the date that one party commences the divorce action. That's the accumulation that we're talking about. So therefore, any assets in these accounts that accumulated prior to the marriage or subsequent to the commencement of the divorce action are not marital and they are separate property. We often hear the question, can we waive these assets? Can the parties trade these assets for other assets in the marriage? For example, the parties have a marital residence and the equity in that residence is $500,000. And they also have a 401k. One of the parties has a 401k for $500,000. Can they trade it? One party keeps the house, the other individual keeps the 401. The easy answer is yes, but there are two issues, at least two. The first is, remember, it is the accumulation in that 401k during the marriage that matters. So for example, you could have a 401k that's $500,000, but if the accumulation during the marriage is only $300,000, then in that example, that trade-off is unequal because the marital residence is worth more. Secondly, and perhaps more importantly, is the tax issue. When parties divide up assets, for example, the marital residence, and then the individual later sells that residence, there typically are no taxes due because of the federal tax laws, exemptions, and other credits that they're entitled to. However, when they draw down on that 401 or start getting that pension plan payment, that is a taxable event. Therefore, the 401, the retirement account, has to be tax impacted to figure out the true value. Because again, that 401k with $500,000 in it may only be worth $350 to $400 after you take out the taxes. The final area in this on this subject of 401s, and again, having to do with waivers and trade-off, is signing certain forms to make sure that everything is in order. We talked before about trading and waiving off assets. You can sign a stipulation, a separation agreement, where you're waiving the asset, where you're giving that asset away and or the party's retaining that asset. That is a binding agreement. Is that the end of the story? Well, it may not be. And the problem is this. During the marriage, parties typically will name their spouse as a beneficiary for their life insurance and sometimes for their retirement accounts. And typically what they'll do is they'll sign a form naming the spouse as a beneficiary and file that form with the plan administrator for the pension. Why is that a problem? Because years later, that has to be resolved. So the parties sign a stipulation of settlement, they sign the separation agreement, but they need to do one more step. They need to contact the plan administrator. Was there a document filed listing the beneficiary as the spouse? Because if that is the case, that needs to be resolved. So what happens? Why is it a problem? Down the road, one of the spouses die, the title spouse. And now the plan administrator may have to distribute certain assets, maybe a death benefit, maybe pension payments, some other asset that was due that title spouse. They will typically look at that form that is filed, and they will look to send the spouse whose name is on that form the benefit, even if it is a former spouse. And so now the new family or the children have to scramble and get in touch with the former spouse to see if they would relinquish what they had already relinquished in a separation agreement. Sometimes spouses are accommodating, sometimes former spouses are not so accommodating. And now you have a problem. You have a costly and potentially contentious situation. You will have to probably litigate this matter in two courts. Surrogates court, because there is a death, and perhaps back in Supreme Court where the matrimonial action was commenced. Take time, take lawyers' fees, and again, fighting with a former spouse. Getting them to do what they should have done years ago. So, how can this be avoided? At the time you sign the stipulation of settlement, make sure you contact the plan administrator. See what they have on file. See if there is a form to be signed. And have that form signed at the same time you're doing the stipulation of settlement. Otherwise, a former spouse may be getting benefits that clearly was not the intention of the parties.